I assume everyone can hear me. If you can hear me, can you wave or something? Yes, thank you. Yes. Yeah, generally. Ms. Curry, can you hear me? Yes? Okay. Okay, my name is David Bouillier. I'm a reporter within the Scottish Government's Department for Planning and Environmental Appeals. I've been asked by Scottish ministers to conduct a public inquiry and to report to them with my findings in connection with two matters. First, proposed Firth offshore wind farm phase 1 onshore infrastructure works compulsory purchase order 2019. And second, proposed certification by Scottish ministers pursuant to paragraph 11, part 3 of Schedule 1 to the Acquisition of Land Authorisation Scotland Act 1947. I've been advised that there may be a joint motion to be put in today by the promoter, the council and the Golf Links Management Committee. And I'm very grateful for having advance warning of that. I'll come to that in a second. And I don't know whether Ms. Curry or Ms. Gordon are aware of that because you weren't directly involved, I suspect, but I'll come to that in a second. But can I just check that everyone that I can see is intending to, oh, and Mr. Owen's just arrived. I'll wait for Mr. Owen to join. Oh, I can do that myself, no. While Mr. Owen's joining, I'll just check that there's nobody that we're missing who might be wanting to take part today. So from the council, I can see Mr. Finlay. And I saw a few of the others join, but I assume it's just you, Mr. Finlay, who'll be speaking for the council today.
Yes, sir, it's just me and everyone else is online but muted.
Okay, thanks. And on behalf of the promoter, again, I can see Mr. Mackay, and I think I did see, I can see Mr. Hamilton there, and I think I saw Mr. Monroe as well. So it's, yes, they were. Hello. So are all three of you intending to speak on behalf of the promoter? Mr. Mackay?
Yes, I suspect I'll be doing the speaking, but Mr. Hamilton and Mr. Patrick Monroe are also joining us if necessary.
Okay, thank you. Great. For the Management Committee, Golf Course Management Committee, Mr. O'Rourke and Mr. Anderson are here, and I think Mr. Irwin was joining. I'm not sure where he's gone, but Mr. O'Rourke, hello.
Good morning, sir. Yes, that's correct. Mr. Anderson and I are appearing for the Golf Links Management Committee. Mr. Irwin of Strutton Parker, I think, is here, and Mr. Milne of Thorntons, who's my instructing agent, is also here.
Thank you. And Teeling Wind Farmers, Gordon, hello. Well, I can't hear you, muted, I think.
There we go, that's better.
Thank you.
Yes, I'm appearing for Teeling. None of the clients are with me this morning, just myself.
Thank you. And for the Ministry of Defence, Ms. Curry?
Yes, I'm here for the Ministry of Defence. That was down from Morton Grant from online, but I'll be speaking out.
I don't know if it was just me, but your audio was a bit garbled there. You.
Oh, sorry. So Ellen Grant from Ministry of Defence and Douglas Milne should also be on the line. I'll be this week.
That was slightly better, but still not great, I'm afraid. I'm sure Ewan is lurking somewhere. What I think you said, Ms. Curry, was that you'll be speaking for the MOD, but that your colleague, Mr. Milne, is here, and I think I also saw Ms. Grant from the client organisation.
Yes, that's right.
Great. Okay, well, many of you attended the first pre-examination meeting back in March, and we agreed that where objectors wanted to be heard, that would take the form of hearing sessions, about a week of those, to start in the week commencing 22nd of June. And at that time, it was just before the lockdown commenced, and there was some discussion. I think it was Mr. Anderson, you in particular raised the possibility that we might not be able to do that in person. And that has, of course, proven to be the case. So since then, I think 4 matters have cropped up which have prompted the need for today's discussion. First is that realisation that we're not going to be able to meet in person at the end of June. Linked to that were some concerns raised on behalf of the Management Committee by, I think, Mr. Irwin, about how we go about handling a large volume of issues from objectors in a sort of virtual setting. I think we're all fairly new to this, and it's probably fair to say it's suboptimal, but certainly he raised some concerns about realistically how easy is it going to be to do it, and how easy is it going to be for interested members of the public or perhaps non-statutory objectors who didn't want to speak but still wanted to be seeing it live, how easy that would be. So that's another issue we needed to think about. There was also the suggestion on behalf of the promoter that certain matters perhaps could be handled in writing, those matters where there is genuine agreement amongst the parties, which would narrow down the scope of what we do via this sort of session. And then finally was the matter that Mr. Finlay had promised at the last meeting, which was the council putting forward details on an alternative site, which was the routing of the line of the routes through the Ministry of Defence land, which of course brought the MOD into proceedings, and that has its own potential consequences in terms of the use of this sort of technology. So that's where we are, and the plan had been, as I set out in my suggestions in the timetable for the sessions commencing 22nd of June, was that we deal with certain matters by virtual hearing sessions using this sort of technology, and quite a few matters I was suggesting could be dealt with by written submissions, either those that have already been made or supplemented by further written submissions as required. So that was where we were up to. I now understand that there was a possible alternative proposal, or perhaps the product of some further discussions between some of the parties. Perhaps easiest if Mr. Mackay, is that the best thing if you were to say where we've got up to on that and what it was you wanted to put to me?
Yes, thank you, sir. And can I say thank you, first of all, for scheduling this virtual PEM, which has helped to focus parties' minds. And it's also, I think, very useful to all of us to have a test run of this technology and to see how it works. So it's very useful for all concerned. I'm very pleased to be able to indicate to you, sir, that following an intensive period of discussion and negotiation, the representatives for Sea Green, Angus Council and Carnoustie Golf Links Management Committee have narrowed the remaining issues to the point that it is very likely that agreement in principle will be reached on all substantive issues in the near future.
Excellent.
Angus Council will then require to reach a formal decision on whether to conclude a voluntary agreement and remove its objection. And it is anticipated, sir, that a decision will be reached by committee of the Council on 22nd May, failing which on around 26th May. And the outcome of the committee meeting will, of course, be communicated to the DPA case officer as soon as possible after the meeting. As a consequence, sir, the principal parties are seeking your approval of a continuation of this PEM for a period of 2 weeks to the 28th of May. And also, sir, in case it proves necessary to hold an inquiry, parties invite you to vary the existing timetable so that documents are submitted on 1st June, hearing statements on 8th June, and any rebuttal statements on 15th of June. Sir, I should mention also that in relation to objection by Teeling Wind Farm, it is likely that a voluntary agreement will be completed in the next day or so, and therefore I understand there's no opposition on their behalf.
Okay, thank you. Mr. Finlay, did you have anything to add to that other than to agree? Or?
Just a little bit to add. First of all, we are nearly there. There are, just so that everyone's aware, in order to get the matter to committee on the 22nd of May, we need to have finalised agreements probably by close of play on Monday. We can start drafting the report beforehand in some confidence as to what they'll be, but we need finalised agreements by Monday. And there are a couple of interacting parts. One is connection with the RNA, which I know Mr. O'Rourke is part clients are dealing with. That's an important ingredient, but all things have come together, as Mr. Mackay indicated. There are two other matters that the council has concern with apart from the golf course. One involves Mr. Mackay, which is about a servitude about crossing a cycleway, and I think we have received a recent draft on that. It's hoped that that will be dealt with too, but that needn't hold up the main issue between the parties. And the second is Morrow's Primary School, and we are hoping to take that to committee also on the 22nd or the 26th of May, as the case may be. But if I can just stress to parties that there is a certain amount of work to be done in formalising the agreements, and for the council, with the best will in the world, they need to be formalised if we're going to hit the Friday meeting by close of play on Monday. So, but in generally, I'm grateful both to my learned friends, Mr. Mackay and Mr. O'Rourke and their clients, and we're all working towards the same outcome.
Thank you. Mr. O'Rourke, did you have anything to add to that?
Well, sir, I can only echo the comments that have already been made by my learned friends, and likewise, I'm grateful for the efforts that have been made to reach this joint position that we're able to put before you, and that my learned friend Mr. Mackay has explained. I entirely agree with Mr. Finlay that there is, although we are close, I think, to resolution of matters, that there are some important steps that still need to be dealt with, and mention was made of the Royal and Ancient and their involvement or indeed interest in these matters. And all I would say about that is it's been dealt with as sensitively as possible by the golf links, and liaising with Angus Council in order to ensure that any concerns that the council has will be adequately addressed by the Royal and Ancient. And those instructing me are in communication, or have been in communication, and there is ongoing communication today and no doubt in the days to follow, in order to ensure that whatever the council requires for the meeting envisaged for the 22nd can be provided. But yes, I should just simply say then, is in terms of the timetable, the proposed very timetable as outlined by my learned friend, I'm in complete agreement with that, and the proposed date for a second pre-inquiry meeting. If I might just add one point, sir, and of course, appreciating that negotiated resolution is hoped for, but in the event that if the inquiry does proceed, I should perhaps just emphasise that the preference of the golf links, of course, was for a hearing not using a virtual format. Clearly, that is ultimately an unrealistic ambition. I can well appreciate. However, what I would respectfully invite you, sir, just to consider is that the golf links would like to reserve its position really at that continued pre-inquiry meeting, in order to consider what features, in addition to what has obviously been very helpfully set out in the agenda. But what additional features the inquiry might usefully have? For example, whether it might be possible to have a site visit of some description using appropriate social distancing measures, or whether it might be possible to provide a video or other material of that kind just to assist with the locality.
Yeah, thank you. That's helpful. That's something that's been preying on my mind as well. I'd said at the March PM I would need to go on site and ideally be accompanied by parties on both sides who can physically point things out, their main areas of concern. There is talk, certainly in our office, about when things might loosen up slightly that would allow some sort of site inspections to take place. We have trialled kind of virtual site inspections where parties go on site with a phone or something, and we're in connection via Zoom, and I will ask them to point the phone at various things to look at. It's far from ideal. So I'm not wanting to go down that route, but if we had to, that would be, you know, I haven't closed my mind to that, but I would much rather, assuming it's safe to do so, you know, get on the site and we'll traipse around separately or 2 meters apart or whatever and see what we can see. It doesn't seem that that will be impossible at some point down the line, but we'll have to see. Just who knows what's happening. But that's certainly a valid point. I think we could talk about in a couple of weeks if that's where we're going. On the Mr. Finlay, on the subject of the alternative site, I guess assuming this all goes to plan, then the involvement of the MOD would logically fall away. There would no longer be a suggestion that their land would be a more appropriate route. Is that right?
Absolutely correct.
So,
so at the moment, we're hopeful that that indeed will be the position.
Fine. Good.
I can't say more than that, but yes, it would, safe to confirm, it would definitely fall away.
Yeah. So, Ms. Curry, I don't know if you're hearing okay. Have you any major objections to us meeting again virtually in 2 weeks' time, and we can then see what has happened amongst the other parties and see how that leaves your client's position?
That would be useful if possible to know sooner rather than like the alternative routes still being insisted on, because there may still be work to do in the meantime. If that's all being insisted on, then work may be necessary.
Sure. Yeah, I appreciate you don't want to do abortive work in the meantime if it's all going to come to nothing. I'm sure they can hopefully keep you apprised of where things are going. Ms. Gordon, appreciate your interest is at the other end of the line, and I know you've been working on behalf of this client to try and reach some sort of agreement. Would you have any objections to, assuming that you need to coming back in 2 weeks' time for a similar session?
No, none at all. I was contacted this morning by Mr. Hamilton, so we're aware of the delay. Our clients are, I would say, yeah, about 2 days away probably from having a signed agreement, or at least missives to conclude. So we'd be perfectly happy with that delay and the proposed timetable.
Excellent. So on the timetable, I'll just write this down. So instead of the 25th of May, we would go to the 1st of June for documents. Hearing statements again moved back a week to the 8th of June. And I think I heard you say the 15th for rebuttals, Mr. Mackay, yes, if needed. This is assuming it goes ahead, of course.
Indeed, sir, that's the proposal.
Cool, okay. That should be okay, because I wouldn't need to rely upon rebuttals necessarily to know where I think we need to go in terms of the agenda. I'm just keen to issue an agenda that is of some use to the parties rather than just being about 4 words on a piece of paper, which sometimes happens, which doesn't really tell people anything. I'd sooner actually have it in more of a form of questions that I would be thinking I need an answer to. But I think I can probably do a lot of the work on that and then have a quick check through the rebuttals if there are any, and then tweak it as necessary, and hopefully get it out within a day or so of that, still giving you a good few days to think about it before we actually go into action on the 22nd, assuming this is all going to happen. So I think that should be fine. I'll issue a little note of this, which will confirm that revised timetable. Thinking if there's anything else needed to raise. I don't think so. Is there anything else? I'll start with anything else anyone wanted to say. Mr. Mackay first. Anything else we need to talk about today?
I don't think so, sir. Really, just to reiterate our thanks to you for fixing the PM and agreeing to the variation to the timetable.
Thank you. Mr. O'Rourke, anything you want to add today?
No, thank you, sir. Entire agreement. Thank you.
Thank you. Mr. Finlay?
No, thank you. Just to reiterate Mr. Mackay's thanks to you.
Thanks. Ms. Curry, anything we need to cover from your point of view?
I mean, I don't know whether this would be best to wait for the continued meeting, but just to confirm whether the MOT that's hearing, just whether we need to put it in witnesses at this stage.
I'm afraid I didn't get that.
Sorry.
By your internet.
Your agenda obviously proposed that the MOD's involvement be by written submission.
Yes.
Just whether that was likely to be the case, or whether we need to put the virtual hearing in any witnesses' diaries.
Yes. No, that's a good point. The reason I was two reasons I was minded to go that way was first the security issues or queries that your client raised about their ability to connect to something like this. And I know, obviously, one of your clients is here in some capacity, but I appreciate that may not extend to giving evidence via this forum, although it is secure, I'm told. But the other issue was whether the response that you gave on behalf of your client was such that it could simply be dealt with by written submissions. Anyway, you've set out your position quite clearly in some detail in writing. I don't know if that's perhaps, it might be helpful today if we could just consider that question as to if things are still to proceed and the question of the alternative land is still a live question, whether we could just address that now as to whether that could in fact be dealt with in written submissions. I suppose I'm really thinking of you, Mr. Finlay, because I think that wasn't your preference or your client's preference initially anyway.
It would cause us some concern, because the real issue is the implications of having an underground cable one side of a line as opposed to just the other side of a line. And one can understand if you were going to put the underground cable through the centre of the MOD land, there would be really serious issues. But the safety implications of having the line 30 yards further away than it is now, in close conjunction to a sewage line, which presumably has to be occasionally, one has to envisage may occasionally need to be repaired, inspected or otherwise. Those are the issues that we're concentrating on. And so it depends upon what the MOD's evidence is. If it's generic and doesn't go down to that detail, then we may be in some difficulty of dealing with it simply by written representation. Those are the issues. I mean, that's an indication of the type of issue which suggests to us that some form of oral hearing may be necessary for some of their witnesses, not necessarily for all, because there may be much of the MOD's evidence which is not actually in dispute. It's the particular circumstances that may need to be examined in greater detail.
I don't want to get into talking about the arguments now, obviously, but the one point that struck me raised on behalf of the MOD was the question of whether you can lawfully CPO Crown land. And is that not a matter we could consider preliminarily, if that's a word? Is that not an issue that we could perhaps consider as a first issue, if that's right, is that not an answer to the question regardless of the suitability?
It's one thing to, yes, that is an issue we could consider, but simply because one can't CPO the land doesn't necessarily mean that the MOD, there aren't other ways of the land being made available. I don't understand that's an absolute bar. So, yes, my understanding is it's an alternative route, not necessarily an alternative route that has to be available by the CPO process. I don't think that's a question that could determine the outcome of the alternative route.
Okay, I don't know, you disappeared for a second there, Ms. Curry. I don't know if you got all of that.
Yes, sorry, slightly. I heard that Mr. was saying he doesn't think it's a good answer to the question.
Yeah, I'm not getting you again. The sound is terrible. Can you try that again, please?
Sorry, I did get cut off for a minute. He didn't give us a complete question.
I'm still not hearing. Sorry. It was all very useful. Test.
Maybe, if I can suggest, it may be better if Ms. Curry turns her video off. She may have bandwidth for greater communication by sound only.
Yeah, that's a good point.
Is that any better?
Yes, thank you.
Yes, yes, sorry, I did get cut off for a minute. I heard Mr. Finlay say he didn't think it was a complete answer to the question, but I may have missed something else.
Right, my question was if you're right that CPO can't be used to acquire Crown land, is that not an end to the question of whether MOD land is a viable alternative? And his response was, we're not necessarily talking about CPO, we're talking about some alternative route being possible in some way. I think that's a summary, unless you do it, displays nothing. Did you have any views on that?
Well, I suppose obviously don't want to get to the merits here, but I think given the other difficulties we've outlined in our statement of case, it might be unlikely that we would be able to overcome those issues and reach agreement another way. I don't know if that's getting too much into the merits just now.
Yeah. Okay, I think sounding like difficult to reach any conclusions at this stage. I think we'll probably need to talk about this at the next PEM, assuming we are still going ahead for the end of June, to talk about the question then as to how we deal with MOD's evidence, whether it can be in writing, whether part of it can be in writing, or whether we actually need to have witnesses from the MOD. So if you don't mind, Ms. Curry, I think we can park that until then, and we'll all meet back up in 2 weeks' time, 28th at 10 o'clock, same procedure, and cover that if we need to at that time. I think that was everyone. I hope I haven't missed anybody out. Anyone raise their hand if they want to say anything else before we go? No? Okay, well, thank you all very much. I'll issue a quick note of what we've agreed today. Ms. Kerr will send out another invitation, same procedure as this, and we'll get back together in 2 weeks' time and see where we've got to. Okay, thank you all very much.
Thank you very much.